Morning, it's April 1st, and this is To My Liberal Friends. Well, the fight between the Trump administration and federal district judges continues, and it's causing major distrust of the entire system. Liberals and Democrats are cheering on these lawsuits, but if the roles were reversed, then they would be demanding that someone put an end to this lawfare. And last week I talked about this, and I said there were two solutions. One would be for Congress to act, and the other for the Supreme Court to take one of these cases and clearly delineate the powers of the executive branch once and for all. And I keep hearing Democrats claim this is a constitutional crisis. They seem to forget that the only court set up under the Constitution is the Supreme Court. The other courts, both district and appellate levels, along with various other federal courts, were created by the Congress. So Congress does have some level of power over these courts. Speaker Johnson has addressed this issue and made the point that Congress could eliminate certain district courts. Now, I'm not going to hold my breath waiting for Congress to act. If the House passed any bill that restrained these district court judges from issuing nationwide decisions of bill, then they would be sent to the Senate, where Democrats would filibuster it, and the result would be nothing gets done. But after some further research, there are a couple of things the Supreme Court can do. The first is, as I mentioned, take a case in the written decision, lay out exactly what the executive branch, meaning the president, can and cannot do. That would be a precedent and would give guidance to both Trump and any future presidents. But there's a second thing the court could do to rein in nationwide injunctions. The court could exercise their authority under the Rule Enabling Act of 1934. They could then amend the federal rules on injunctions. The recent outbreak of nationwide injunctions damages in my opinion, our constitutional system. They were almost unheard of before the 1960s. Only 12 were issued against George W. Bush and 19 against Barack Obama. During each of their two terms, Joe Biden faced 28. Mr. Trump faced 86 during his first term, almost all issued by Democrat-appointed judges. 2 months into his second term, more than 15 have already been issued, and the number's growing every day. Because nationwide injunctions often appear politically motivated, they create cynicism about the courts and the law. Worse, they enable lower court judges to thwart the president's Article II authority, even in national security and defense issues. Nationwide injunctions are issued under Rule 65 of the Federal Rules of Civil Procedure, and this was created under the Rules Enabling Act. Rule 65 authorizes district courts to issue preliminary injunctions, but it's silent as to whether they have nationwide effect or apply only to parties before the court. This ambiguity can be eliminated by an amendment to Rule 65 without the need for new legislation. The Rules Enabling Act empowers the Supreme Court to, quote, prescribe general rules of practice and procedures, end quote, such as the Federal Rules of Civil Procedure. The Supreme Court can prescribe them on its own section under Section 2072. The current situation begs for action by the court. District judges are imposing their own political interpretation of the law in the entire country, and that was never the intent of the Congress when these courts were set up. There's one other issue that can put a stop to all this forum shopping by Democratic attorneys. Again, going back to Rule 65, and this time Section C, it requires the party seeking an injunction needs to put up a bond to cover its costs. These bonds aren't optional. They're mandatory unless the government's seeking an injunction. And that means Judge Boasberg's order, which he issued last week, and dozens like it, may not be valid at all. President Trump identified this legal off-ramp in a March 11th memorandum directing the Justice Department to demand bonds in future injunction cases. Senate Judiciary Chairman Chuck Grassley echoed the call, but the Justice Department hasn't pressed the issue either in Judge Boasberg's courtroom or other high-stakes cases in which activist judges have blocked major policies without requiring plaintiffs to put a single dollar at risk. Far from a technicality, this is a fundamental failure to follow Rule 65C. The text, legislative history, and appellate court precedent, including from Judge Ruth Bader Ginsburg of the U.S. Circuit Court of Appeals for the District of Columbia, when she was there, all confirmed that a bond isn't optional. It's a legal precondition for an injunction to be valid. The Fourth Circuit has made clear that the bond rule isn't discretionary. Only the government may attain an injunction without posting a bond. There are no other exceptions. The Third Circuit has characterized the bond as a, quote, conditioned precedent to issuing injunctive relief. According to the Fourth Circuit, failure to require a bond before granting preliminary injunctive relief is reversible error. Activist judges continue to sidestep the rule by setting nominal or de minimis bonds. Courts have some discretion in setting the amount, but it must be, quote, proper to pay the costs and damages sustained by any party found to be wrongfully enjoined, end quote. That means those bonds got to be a lot higher. In practice, what's happening now is the cost is rarely zero, and appellate courts have repeatedly struck down attempts to treat it as such. The appellate courts are saying, put up substantial bonds. Enforcing this rule would mean that lawyers seeking those injunctions would have to have the financial resources behind them, and to understand if they then lose on appeal, those bonds would be forfeited to pay the damages suffered by those opposing what the plaintiffs seek. Let's force everyone to play by the rules. We might actually see some real results, and we might see some of this activist lawfare in the courts end. This has been To My Liberal Friends. Thanks for listening.